Hello, everyone. It's a privilege for me to connect with you here, all our students, right? I want to proceed on my earlier session that I did introducing you to commercial law. My goal is to try as much as possible and explain concepts, complex concepts, into very simple principles so that even if you do not have much time to read, it is the understanding that you get from here that should enable you actually pass your examinations. You can always reach out if you have any questions or concerns, right? If you remember in my other session, I spoke about the sale of goods contract, a sale of goods contract, right? And I said we are going to heavily depend on the Sale of Goods Act, Act 137. So kindly grab a copy wherever you can get one because we will peruse it a lot, right? You cannot be that much successful without the act. I spoke briefly about a sale of goods contract where I made reference to section 1.1, right? And the import of section 1.1, looking at what is a sale of goods contract, is where the seller agrees to transfer property in goods to the buyer for a consideration called the price, consisting wholly or partly of money. So, in every sale of goods act or every sale of goods contract, there must be the seller, the buyer, an agreement, transfer of property in the goods, and there must be the consideration called the price. L'argent. All of us love money, right? So it will not be good for you to be doing a business where you sell goods to people and you will not get money for it. So money, the price, the consideration, very, very important. If you remember, I indicated that in my subsequent session, I'm going to run you through some contracts that resembles sale of goods contract, but are not sale of goods. In some peculiar circumstances, there are some contracts that resemble sale of goods contract, but they are not sale of goods contract. So that is what I want to do in this session, run you through them quickly, and then I will give you some authorities on what goods are. Later, I will come and take goods as a topic into details because we have to look at what are goods, what are actually movable items, right? And so we would look at goods and the various types of goods that we have. So, once again, as I said, this is a platform where we learn. And even if you listen to me and you are not able to have much time to read, you should be able to understand the principles and then have your way through. Take note that as far as section 1.1 of the sale of goods is concerned, there is a seller, there is a buyer, there is a good, and transfer of property in the goods from the seller to the buyer for a consideration called the price. So, what are some contracts that in peculiar circumstances resemble sale of goods contract but are not sale of goods contract? The first example is a contract of barter or exchange. If I have my mobile phone and I say I want to exchange it for your book, it resembles sale of goods, but it is not a sale of goods contract. Another example is a contract of bailment. between the bailor and the bailee. This is just for custody. I have a bail, I'm giving it to you. You are just keeping it for me. When I need it, I'll come back. I'll come back for it. This is not a sale of goods contract. We'll come and look at contract of bailment later in the second semester. A contract of hire purchase is the third one. A contract of hire purchase is not a contract of sale. So, if I have a mobile phone and you come to my shop to take a very nice mobile phone, and we agree that you will pay in 6 monthly installment, you take the phone away, you will make an initial deposit of, let's say, 100 cedis. You've taken the phone away. This is not a sale of goods contract. In every sale of goods contract, don't forget there is the buyer and the seller and the good. But in a contract of hire purchase, we don't have a buyer and a seller, at least in the initial stages. So while you pick the phone, you are the hirer. You are hiring the phone. And I am the owner of the property. So a contract of hire purchase must be distinguished from a contract of sale, because in a contract of hire purchase, where you come to my shop and you are giving me 100 cedis to pick a phone on hire purchase, you are hiring the phone for 6 months. So every month you pay me 100 cedis for keeping the phone, because you've hired it. When you hire an item, you are supposed to pay for keeping it. So if you enter the shop and you pick the fridge and you are paying in 4 monthly installment, you have not bought it. You have hired it. As long as you are keeping the fridge, you are supposed to be paying at the end of every month. Later, or the final payment, we can bring in sale of goods. But as I said, we will get into contract of hire purchase second semester, because at a point in time, a hire purchase could metamorphose into becoming a sale of goods contract. But at the initial stages, a hire purchase contract is not a sale of goods contract, because it involves you, the hirer, and me, the owner of the phone. A contract of supply of service or services is not a sale of goods contract. Personal service, assuming what I'm doing, I'm getting consideration from you. I am the provider. You are the recipient of the information. And at the end of the day, you are giving me a consideration, let's say $10 million every hour for what I'm doing. Wow, that's a lot of money. Right? I'm still, or I'm still not a seller, and you are not a buyer in this context, right? And of course, there is no any good. So it resembles, or I can still be, let's say, the seller of my services. You are the buyer, but goods, there is no goods with me over here. So then I am not entering into a contract of sale with you. Contract of agency, agent principal relationship. We'll come and look at that also in second semester. That is not a contract of sale. Finally, licenses of intellectual properties, specifically the sale of computer software. So many of you buy computer softwares, you install them on your computers, that is not a contract of sale, even though we'll call it a sale of a computer software. Now, so it means that there is a contract of sale on one side, and there are these contracts also on another side. What are these contracts? Let me mention some of them again. A contract of barter or exchange, number one. Number two, a contract of bailment. Number three, a contract of hire purchase. Number four, a contract for the supply of services. Number five, a contract of agency. And the last one, a sale of computer software. These are also on one side, where in peculiar circumstances, you see that they may resemble sale of what? Goods, but they are not sale of goods contracts. So what is one of the cardinal distinguishing factors between these contracts and the contract of sale of goods? One of the key distinguishing factors, right, take note of this, is that in every sale of goods contract, there is the transfer of all the rights in property in the goods to the buyer in exchange for a price. So in every sale of goods contract, there is always the transfer of all the rights in property in goods in exchange for the price. So if I am selling to you my mobile phone, where we are entering into a contract of sale of goods, I am the seller, you are the buyer. Once you pay the price, there is the transfer of property in goods to you. So you can take the phone and go and give it as a gift. That is a contract of sale of goods, because property has transferred from me to you. So you can deal with the phone anyhow you want to. But juxtapose this with a contract of hire purchase. You cannot do that in hire purchase. When you pick the item on hire purchase, you cannot go and give it as a gift, because property has not passed. The rights in the property hasn't passed. You've just hired it. You cannot hire somebody's item and go and give it as a gift. So, once again, the distinguishing factor between a contract of sale of goods and the other contract is that in a contract of sale of goods, there is the absolute transfer of all the rights in property in the goods in exchange for the price. Kindly note that a contract of sale must first and foremost be a contract. Must first and foremost be a contract. Now, how is contract understood in the law at large? So, irrespective of a legislation, and that legislation contains contract, we are saying contract must be understood in the law at large. So wherever you see contract, it is contract, and the contract that you know first year, right? So what is a contract? I hope you've not forgotten. A contract is an agreement consisting of exchange of promises between parties, which the court recognizes as giving rise to enforceable rights and obligations. And one of the cardinal principles in every contract is consensus addendum. Consensus addendum. So a contract of sale must first and foremost be a contract of sale. It means that there must be consensus addendum, the meeting of minds between who? The parties. Who are the parties? The seller and the buyer. If I am the seller, I must agree from my heart to sell the phone to you, and you must agree from your heart to buy. So this consensus addendum of selling and buying a property, a good, is what constitutes a sale of goods contract. Now, what is goods? What are actually what? Goods. If you want to know what goods are, you would go to the interpretation section of the Sale of Goods Act, Act 137. I'll come and treat goods on its own, but to introduce you to some two cases. Goods is defined in section 81 of the Sale of Goods Act. And I want to read that verbatim to you. As I said, you have to get your Sale of Goods Act. So section 81 defines goods as goods means movable property of every description and includes growing crops or plants and other things attached to or forming part of the land which are agreed to be served before sale by or under the contract of sale. I would come and treat goods again, but kindly note that goods refer to movable property. Movable property. So it means that when you sell and what you have sold does not involve a movable property, something that can be moved from one place to another, then that is not a sale of goods contract. It's something else. It's something else. So I keep using the phone, the fridge, microwave, another example, as examples of sale of goods contract because a mobile phone is movable, can be moved from one place to another. A microwave can be moved from one place to another. Fridge can be moved from one place to another. So anytime there is a consensus addendum between two parties, one the seller, two the buyer, to sell to the buyer for a consideration revolving around a movable item or property or asset as the subject matter of the contract, then that will be a sale of goods contract. So you look at the case of Halabi versus Wiredu, Halaby versus Wiredu, Wiredu. Halabi versus Wiredu. This is an alien, or let's say a foreigner who came into the country and he was involved in the sale of spare parts. This was in the 1970s around Swami in Kumasi. There was a law that all foreigners should leave these small businesses for the local people to take over. So he had a shop full of spare parts. He needed to leave the country. What will he do? Can he take his spare parts into a car or a ship or a cargo, and then take back? No. The best thing he could do was to sell the shop. And the shop contained the spare parts, which is the stock in trade, the spare parts. So he sold the entire business to a Ghanaian to pay him in installments. Now, the question, when there was default in payment, the question that the court has to ask is whether or not the transaction between this foreigner and the Ghanaian is a sale of goods contract, so that we can use the Sale of Goods Act to resolve the matter. The court held that what was sold was the entire business, the goodwill of the business, the organization, and that cannot constitute sale of goods contract. I hope you get it. So where I sell to you my company, my entire company, the goodwill of the company, the customer links, the trade secrets, I sell to you everything. Even though that company may contain movable items, that will not be a sale of what? Goods contract. Because it is more than that. It is involving the sale of a business, the goodwill of the business, the trade secrets and all that. That cannot be a sale of goods contract. Another case you can look at is Nano versus Auto Parts. Nano versus Auto Parts Limited, NANOR versus Auto Parts. This was an agreement between two parties for the sale of a Nissan Homer 23-seater bus. A Nissan Homer 23-seater bus. Even this one, if I don't go ahead and then talk about the details of the facts of the case, you have to know that this agreement or contract is a sale of goods contract. Why? A Nissan Homer bus, a car, is a good which is movable. So where party A and party B agrees to sell a Nissan Homer bus, that would constitute sale of goods contract, nothing more, nothing else. So look at the facts of the case where the party failed, the auto parts actually failed to deliver what the buyer paid for, and that dispute is what the court have to resolve. But for the court to know the appropriate provisions to use in settling the dispute between them, the court has to decide what is the contract. Is it a sale of goods contract or is something else? The court came to the conclusion that the sale of a Nissan Homer bus is a sale of goods contract because goods includes movable property. So don't worry, I'll come back again on goods because goods is one of the topics that we'll be looking at into details, where we'll look at the various types of goods, right? So you can always reach out if you have any difficulty in any subject that you are studying. It is more than easy. I hope that this video has been a blessing to you, and do not hesitate to reach out to me once again if you have any concerns or questions. Until I see you in my next video, stay blessed and bye for now.